because by doing that, you're distracting your attorney from paying attention to a testimony of the opposing party. And you might miss an objection. It's a matter of seconds. And if it's not objected, it's admitted. So you have to I hate to call it a game, but it's a listening game that we have to actively listen. And if it's something critical or important, yes. If it's something that can wait, just write it down, wait during the break. And I see that because sometimes I'm taking depositions, they're via Zoom. Sometimes the clients are trying to be helpful during a hearing. They send me text messages. It's important. It's impossible to pay attention to two people at once. So let your attorney do his job or her job, focusing on the trial. During the break, address whatever issues that you might want to talk about. There'll be a lot of legal maneuvers and legal procedures that are going to be completely out of your head. That's understandable. We know what we're doing. But it's important to allow the attorney to be in the driver's seat this time and just let him drive, or let her drive, okay, without disruptions or without interruptions, because that is important to your case. As I mentioned earlier today, at the beginning of the podcast, settlement is always an option. If you feel the case is not going your way, which could happen, something that you said or something the other side said, or something common that the judge might have made based on some of the questions, you can always try to settle the case before a verdict is rendered. There's nothing preventing that. We can ask if it's a possibility for settlement. We can ask the judge, can we have half an hour break? As a possibility we might settle this case. We want to have a conversation with opposing counsel. Can we get a room in the courthouse so we can talk about it? They'll do it. They'll give it to you. So you got to be nimble and flexible. Can't use the same word. You have to have the flexibility to adapt to new circumstances that occur at trial. So you always have that in your mind, have that open mind that if things are not going your way, settlement might be an option. Likewise, if things are going your way, the other side might say, you know what, we want to settle this. But the reality is this. We can have the best possible case, present the best evidence. We do not know what the judge is going to do, what the jury is going to do. We do not know that.